Hey, welcome back, everybody. You should have gotten an email from me last evening containing the statutes that we're going to talk about today, the sections of 1701.01.86 to 1701.883. And you should have also received two supplemental cases from me. I put it in one PDF so you wouldn't have to look up things in different places. All of these items, however, are on the class website. And I realize this is a little awkward if you're looking, especially if you're looking at this on a phone. You may not have access to another screen to look at the PDFs on, so you could also print them out. But I think this lecture will make a lot more sense to you if you have the statutes in front of you. And just FYI, I think we may try to do next week's classes in a live Zoom meeting. I'll circulate information on that later. Since it's our last week of class, I thought we might give that a shot. So let me know if you have any problems ahead of time at meeting at our regular time, or if there's another time of day on Tuesday and Thursday you'd like to meet. You can email me with your preference in that regard. I'm not fixed on our regular class time, nor do I suspect are you, given the fact that everybody's doing everything online these days. So if we could map out an hour and 15 minutes, an hour and a half on Tuesday and Thursday this coming week to talk about limited liability companies, I'll circulate the Zoom dial-in, and that way I can also share my screen with you and you can see some of the materials that I'll be referring to during those presentations. Okay, let's talk about corporate dissolution and winding down. So far this semester, we've covered just about everything related to corporations: formation, capitalization, management, operation, and fundamental business transactions involving corporations. So it seems appropriate that in our penultimate class, we discuss the end-of-life issues in terms of corporations. How does one actually terminate a corporation in an orderly manner? Are there any liabilities associated with dissolving a corporation? This last question is particularly interesting given the fact that many companies are dissolved in the aftermath of a failed business or in the context of disputes between the owners. What procedures are involved? What are the legal rules? And why would anyone want to dissolve a corporation? Earlier in the semester, we briefly looked at a specific procedure for terminating the legal existence of an Ohio corporation in the context of a merger in which one corporation disappears and the other corporation is the survivor. We also touched on this when we looked at conversions of corporations into other types of entities with the result that the old corporation ceases to exist as a corporation. Actually, as I look at our syllabus, I don't think we covered conversions. That is a procedure where one type of legal entity is converted into another type of legal entity, and the former form of entity, in fact, is dissolved. Okay, let's move on and talk about this in a little more detail. Preliminary comment: there is a difference between the legal dissolution of an entity and the winding down of an entity and its business. Winding up, winding down, same process. Dissolution is a legal process that has the effect of causing the entity, as a legal entity, to cease to exist in the eyes of the state. Winding up, on the other hand, means the process of actually dismantling the business, selling assets, collecting accounts receivable, paying debts, paying employees and contractors, paying taxes, and distributing what's left to the shareholders in the form of liquidation. Keep this in mind as we go through the rules. So I mentioned in the syllabus that we have a section of the code that covers all of what we're talking about today. And as you might expect, it's at the end of chapter 1701. the end of the corporation, the end of the chapter. So by now you've had a good chance to become with Chapter 1701, and you may have had a chance to, at one point or another, take a quick look at 1701.86 to 883. And hopefully you've looked at them in particular, preparing for this lecture. As I mentioned at the beginning, this lecture is going to be most meaningful to you if you have the statutes in front of you. All of the statutes are also on the class website, which I know you look at on a daily basis. Even if you don't have the statutes in front of you as you listen to this tonight, at some point I will send out the PowerPoints that are not a video, the regular PowerPoints, and they have hyperlinks in them to the materials. So if you can view the PowerPoints sometime later and click on the hyperlinks within those, you'll see the same statutes I'm talking about and the same ones that I sent to you as a PDF last evening. If you take time to look at the legislative comments at the end of the statute text for the statutes in this section, you'll see that there were major changes to the sections of the code related to corporate dissolutions, effective May 4th, 2012. So much of which we're discussing this evening is relatively new law in the grand scheme of things. Let's look at some basic provisions governing dissolution and winding up. Here's a not uncommon fact situation. Let's say you met with 4 individuals in your office who asked you to set up a corporation for them to operate their clothing business. You drafted and filed the articles of incorporation, which authorized the issuance of 1,500 common shares without par value. You also actually issued shares to the shareholders by certificates, and they in turn elected themselves as directors and adopted a code of regulations. Let's say it's the same one that we've been looking at all semester. The directors then appointed 2 of their number as the officers of the corporation, and the board then convened its initial meeting to discuss the company's business, during which it became apparent that these individuals were not going to work well together. They conclude that getting into this business and forming this corporation was a mistake on everyone's part. Now, this is not that unusual of a scenario once people get a little bit into the details of actually forming a corporation, getting serious about their business. So the question is, how can this corporation be dissolved in this scenario? If you pull up 1701.86, this is our basic statute in this series governing voluntary dissolution of a corporation. If you pull it up, you'll see that they require that the corporation adopt resolutions authorizing the dissolution, and they talk about the fact that the directors may adopt articles of dissolution in certain instances. And it also talks about the fact that there's a certificate of dissolution that gets formed by the state in order to put the state on notice that the entity has dissolved. Subsection A says a corporation may be dissolved voluntarily in the manner set forth in this section. Section B says a resolution of dissolution for a corporation shall set forth that the corporation elects to be dissolved, and it talks about what the resolution may include. Section C says if an initial stated capital is not set forth in the articles, then before the corporation begins business, or if an initial stated capital is set forth in the articles, then before subscriptions to shares shall have been received in the amount of the stated capital, the incorporators or a majority of them may adopt by a writing signed by each of them a resolution of dissolution. Now, I would submit that's what's going on in this case. We talk about the fact that we formed the corporation we've issued shares without par value. They have not even begun to conduct any business. So in this scenario, this is an easy dissolution process where the incorporators themselves can file, I will refer to it as a short form dissolution certificate. So this is in the early stages of forming the corporation, easy to get out of it before they've done anything of substance. Let's talk a little bit about what I just mentioned, this item called a certificate of dissolution. And this should always also be in the package that I sent to everyone. If you look at the certificate of dissolution that I sent in the package last evening, after you get past our standard cover sheet, you'll see that we of course need to list the name of the corporation, its charter number, where its office is located, and the address of each domain name held or maintained by or on behalf of the corporation. This is so that, as we'll see later, creditors of the corporation maybe know where they might have found it or might have looked for that corporation before it was dissolved. You'll also see that the statutory agent name needs to be restated, again, because this might be the only warm body around who can actually find anybody associated with the dissolved corporation. You can indicate the date of dissolution if it's some date other than the date of filing. You can set a date in the future, but not a date in the past. On page 4, we need to indicate the manner in which the dissolution was adopted. You can see that there's an option for the 1701.86C dissolution by incorporators we talked about before. Subsection D, the resolution of dissolution adopted by the directors. And you'll see that in that instance, when it's adopted by the directors, there have to have been specific grounds for the directors to have adopted that resolution of dissolution. For instance, the corporation's bankrupt, a receiver has been appointed, all the assets of the corporation have been sold at a judicial sale or otherwise, meaning that if you've had an asset transaction where you've sold all the assets and all you're left with is a shell, you could dissolve checking this particular box. We haven't talked about it much, but a corporation's charter can be canceled when they don't pay any commercial taxes that they're required to pay, and of course when the period of existence has expired. It goes on to talk about the 1701.86E procedure for dissolution by the shareholders. And of course this has to be signed by the appropriate persons. One thing we'll talk about more in a few minutes is this idea of notice to claimants against the corporation. In earlier days, this wasn't part of the regimen for dissolving a corporation. Now it is, which is a great benefit to creditors of a corporation who otherwise were left holding the bag in many cases. On page 7 of 9, there's an affidavit that is required to be filed by the people who are dissolving the corporation in lieu of obtaining releases from all of these corporations that the entity dissolving has no liabilities to those agencies. Your client has to sign an affidavit saying that they've in fact notified Ohio Bureau of Workers' Comp, Ohio Job and Family Services of the fact that they are dissolving. Why? Because these entities are ones who typically collect taxes from every kind of corporation in Ohio, and you need to let them know that you're going to dissolve. Otherwise, they're going to chase you around for taxes. This is something that you're saying that you've done this. You actually have to do it. Otherwise, your client risks a lawsuit from the state for dissolving improperly, and then of course that has to be notarized also. If the entity has personal property that could be subject to a personal property tax in Ohio, they have to address that in page 8 of 9. And then of course to the helpful instructions that come after this. Another thing that's important when you file one of these dissolutions is that you're required to obtain something called a certificate of tax clearance from the Ohio Department of Taxation. What is that? Well, like the name suggests, you have to get the Ohio Department of Taxation to issue a certification that your dissolving company has paid all sales taxes, if it's subject to sales tax, and that it's paid all of its payroll taxes, which it's subject to probably no matter what. Once you have that tax clearance certificate, that gets filed along with the certificate of dissolution, and the state will then recognize the fact that you have caused the entity to cease to exist. The last thing I want to mention in this regard is the applicability of 1701.95. I didn't put that in the package that I sent out, but when you look at it online or on the website for the class, you'll see that directors are jointly and severally liable to the corporation if they vote for or assent to, among other things, the making of a loan other than in the usual course of business to an officer, director, or shareholder, if it has the effect of causing the corporation to be unable to pay its debts. This is a trailing obligation that survives dissolution of the corporation. And of course, a lot of closely held companies play fast and loose with accounting and commingling between corporate and personal obligations. This is a reminder that at times these obligations can survive and follow the directors after they thought that they had dissolved the corporation and had no further obligation. All right, there are 5 digits for tonight's lecture, and I will actually give you all 5. The first one is the letter S. The first code is the letter S. Here's another not uncommon situation. For the last 6 months, your client has been supplying sheet metal to Stampco, a company which stamps auto parts from the sheet metal and then sells them to General Motors. The reality of doing business with GM, of course, is that GM dictates the terms of sale in almost every instance. In this case, Stampco has paid your client for the sheet metal as and when possible, blaming slow payment on the dictates of GM. When the accounts receivable owing to your client reaches a critical level, your client begins placing daily phone calls to Stampco. This continues for a couple of weeks. Later, your client drives by Stampco's plant and sees that the place is padlocked, shuttered, lights out. Its phone has been disconnected, as has its email, which bounces back when you try to send a message. Its website has been replaced by one of those generic placeholder web pages, and texts aren't coming back, they're bouncing back too. Your customer eventually learns through his connections in the trade that Stampco has ceased operations, sold off its assets, and its owners are nowhere to be found. Well, how could this happen? Let's talk a little bit about 1701.87. Prior to May 4th, 2012, this was not an uncommon situation for a corporation to dissolve without giving notice to its creditors. Obviously not good for you if you're a creditor or a lawyer representing a creditor. If you look in the materials that I sent you, prior to May 4th, 2012, the sum total of the procedure for giving notice of dissolution consisted of one paragraph, simply saying following the filing of the certificate of dissolution, the directors or incorporators shall cause a notice of dissolution to be published once a week on the same day for 2 weeks in a newspaper of general circulation in the county where the business is located, and shall cause written notice to be given either personally or by mail to all known creditors of all known claimants against the dissolved corporation. That was it. As you might guess, most companies made a half-hearted, if any, effort to comply with this statute. First of all, it happens after they filed for dissolution. It only has to be published for 2 weeks. When they say a newspaper of general circulation, that can include something called the Legal Times. If you practice here in Cleveland, you'll know that's a publication that exists solely to comply with statutes like this, and that it's read by no one except lawyers. And even then, you can probably count on one hand the number of lawyers you know who've actually looked at a copy of the Legal Times. Fast forward to May 4th, 2012. This is the new law we're talking about, and this is the one we're going to focus on in our practices. Now 1701.87 says the corporation has to give notice by certified or registered mail, return receipt requested. The notice has to be very specific in terms of what it says. That's not just that, hey, we dissolved 2 weeks ago. It has to say that there's a claims procedure. You have to tell everyone who is an actual or potential creditor against the dissolving corporation that they have 60 days to submit a claim to the company. You have to tell them the address they have to send it to. In other words, you can't move off to Tahiti the day you dissolve. You've got to stick around. It also indicates that there's a bar date at that 60-day point, after which they'll be out of luck if they don't submit a claim. Now, it also goes on to say that we're going to go ahead and make distributions to folks without further notice to anybody. And goes on to say that a claim is barred if you've received written notice and you don't submit a claim by the deadline stated in the notice. Those of you who have ever been involved with any probate or wills and estates work, you'll know that there's a similar cutoff date for claims in the case of those who die intestate in Ohio. The statute goes on to say that the corporation has to post this notice on any website that the corporation maintains and has to give a copy of the notice to the Secretary of State. You can't just say you did it. You have to tell the state, show the state that you did it. And that the Secretary of State will then make this listing available in a searchable format on its website regarding the corporation having filed a certificate, the corporation having delivered the required notice. When I send you the live version of these slides, you'll see that there's an actual registry of dissolved corporations. If you are the lawyer who gets the call saying, hey, our customer isn't answering any calls, we hear they went out of business, that's a sign for you to get on the registry of dissolved corporations to perhaps give your client the bad news or the good news that you're still within the 60-day period and can file your claim. So let's look at another fairly typical scenario that comes up in this area. Let's go back to our first hypothetical with the 4 individuals who formed a business to make apparel and clothing. Let's assume that they got through their initial hesitation, successfully ramped up their business by leasing a manufacturing facility, leasing industrial grade sewing machines, some packaging equipment, computers, office equipment, computer software licenses for design packages, company vehicles, etc. The business has been phenomenally successful during the last 10 years. Folks all over the world are wearing clothing bearing the distinctive logo, and the owners have made enough money to retire. They have already sold the trademark rights in the logo to a third party. Now they would like to wind down or wind up and then dissolve the corporation. What procedures govern this process? As I mentioned at the beginning of the talk, winding up is a process of literally disassembling the legal and business infrastructure of a corporation. And as you might expect, we have a statute that gives us some guidance on how this should work. I'm talking about 1701.88, which again is in the materials that I sent out last evening. This is an interesting statute. It talks about the fact that once a corporation has filed its articles of dissolution, and by the way, these always get accepted as long as you've filed the required papers the notices, the copy of the notice, the tax release from the Department of Taxation. But once you've filed those papers and you've complied with the statute to put the dissolution in motion, corporation shall cease to carry on business and only do such acts as are required to wind up its affairs. So it goes on to say that it'll continue as a corporation for a period of 5 years for this purpose. This means that, as I said before, dissolution in the purest sense is simply terminating the existence of that legal entity with the authorities who authorized its formation in the first place, that is, the Secretary of State. It continues for the limited purpose of winding up. Why? Because things still need to be done. Assets have to be sold. Contracts have to be terminated. Employees have to be let go, and unemployment may have to be processed, et cetera, et cetera. So the fact that there is a dissolution doesn't mean that there's a cessation of activity. In fact, there still could be significant activity for years, and the statute talks about 5 years at the outset to try to get all this wrapped up. One thing that's significant about the statute talking about this winding up process in subsection B, the voluntary dissolution of a corporation shall not eliminate or impair any remedy available to or against the corporation or its directors, officers, or shareholders for any right or claim existing or liability incurred prior to dissolution, if either of the following apply. The corporation acts within the time limit permitted by law, that is, within the statute of limitation, and any other person has 5 years to take action. So, in other words, there are surviving liabilities even in the case of dissolution during the winding up period. If the shareholders want to sue the directors or officers in a derivative action, that survives for 5 years, for instance. If the corporation wants to sue one of its suppliers who didn't pay them prior to dissolution, that cause of action survives up to the applicable statute of limitations. The statute goes on to say that the directors of the corporation or their successors shall act as board of directors during the winding up period. The directors shall proceed as speedily as practicable to complete winding up of the affairs of the corporation, but in that process, in that limbo period between the formal dissolution and completion of winding up, the board of directors can still fill vacancies on the board if they have to make decisions during the winding up process. They can elect or appoint officers in case you still need to have officers during the winding up period. They can appoint liquidators or other folks like auctioneers to sell off assets. They can carry out contracts that were in existence. They can even make new contracts. They can borrow new money. They can pledge property of the corporation as security, et cetera, et cetera. If you read through this, you'll see that there's substantial amount of authority that the corporation's directors still have during the winding up period. And you'll also note that subsection E, you'll see in subsection E that during this winding up period, the corporation may apply to have a court supervise the winding up in case people aren't acting nicely with each other, which is often the case in these liquidation, winding up, dissolution scenarios. You'll also see that there's a reference in subsection D to 1701.76. Remember, that was the section of the code that talks about an asset purchase transaction. This statute, this winding up statute, cross-references the more specific provisions of 1701.76 that deal with dispositions of assets in an asset purchase transaction. Important to note that cross-reference in case you get a situation on an exam that involves an asset purchase transaction with these sort of winding up and liquidation possibilities. So we spent a decent amount of time going through the very basic statutes regarding dissolution and winding up. Let's look at the first case we have. This is the Columbia Title versus Columbia Title Agency case. And as you may know, if you know anything about title insurance, Columbia Title Insurance Company is the company that writes the insurance policy. Columbia Title Agency is a separate legal entity that sells those insurance policies to customers. In this case, the question is where the articles of a corporation are canceled for payment of franchise taxes, does the corporation continue to exist during the winding up period pursuant to 1701-88? This case was also in the materials that I sent out to you last evening. Oh, by the way, the second character of the code, the attendance code, is the letter N. The second character of the code is the letter N. So what's going on in this case? The plaintiff is Columbia Real Estate Title Insurance Company, who sued Columbia Title Agency and Joseph Kelly and Mark Keller and Kelly and Keller, a law firm, and individuals apparently were involved with the title agency itself. Maybe you'll learn about this when you start to practice. A lot of lawyers, especially in smaller communities, also own title agencies, and it dovetails into their real estate practices. That's what was going on here, and I'm not going to go through all the facts of the case, but the agency's articles were canceled in 1977 for failure to pay, at that time, corporate franchise taxes. Remember, we talked about those the second week of class when we talked about one of the considerations in determining where to incorporate. They did not pay theirs. That is, under the statutes we've looked at, grounds to have your charter terminated. Keller buys into the corporation in 1978, and the insurance company, the plaintiff, and the agency enter into a contract in 1979 where the agency agrees to try to sell policies written by the insurance company itself. The agency fails to pay premiums on its policies that it had purchased, and both owners of the agency, as well as the law partnership of which they were equal owners, are sued also. Kelly, Joseph Kelly, essentially defrauded the insurance company as well as his co-defendants and the banks that were involved, because there are always banks involved in these real estate transactions, and the buyers and sellers of property by converting funds to his own use, therefore making them unavailable to pay the title insurance company that sold the policies. And so the insurance company sues all the entities, defendant entities, and individuals. So what was the plaintiff's legal theory here? Since the charter had been canceled, so argues the plaintiff, the agency defendant was in fact a partnership per 1775.05a. And the way they got there, of course, is if you look at 1775.05a, this is back to our definition of partnership that we talked about in the first week of class. A partnership is an entity of two or more persons to carry on as co-owners a business for profit and includes such an entity that has limited liability as provided in this chapter, and it is registered under 1775.61. That would be a limited partnership. But they took the basic definition of a partnership and said that because the charter of the agency had been canceled, these people are in fact a partnership. And as a partnership, Keller, who apparently was the last man standing in this whole debacle, is liable for the actions of his co-partner, Kelly, who apparently rolled over in this case and made a deal. And as we know, partners are vicariously liable for their co-partners' actions and commitments, subject to controls that are put in place in a contract or otherwise expressed to a third party. So how does the court react to plaintiff's theory of liability in this case? Well, they say no, that doesn't work. And if you look just down the page slightly at 1775.05b, it says that you aren't a partnership if you formed an entity under another provision of Ohio law, say, for instance, the corporation statute, which kind of takes the wind out of the sails of the plaintiff's argument. Nice try, but unfortunately, The legislators thought about that, and they carved out the instance where there might be a problematic business formation, as in this case. They also argued that the court said that no, that your theory also doesn't hold water because under 1771.88A, which we just talked about, a corporation continues to exist even after cancellation of its charter or dissolution of its charter for purposes of winding up. And so the question is, was entering into the contract with the insurance company part of, quote, winding up, quote, for purposes of 1701.88? If you look at 1701.88 D4, the statute specifically contemplates continued corporate existence after the articles are canceled. Therefore, Columbia Title Agency continued to exist as a de jure, that is, formally, correctly formed corporation for purposes of winding down, and that included entering into the contract with the insurance company. As a result, no personal liability for Keller, because the corporation continued to exist as a corporation during the winding up period. Aside from lawsuits such as Columbia Title, what happens if the winding down process does not go smoothly? What if the shareholders are not getting along, which is extremely common? In these types of cases, we have 1701.89, which is judicial supervision of winding up. This statute also contemplates continued existence for a limited amount of time. It states that under subsection A, the Court of Common Pleas of the county in this state in which the principal office of a voluntarily dissolved corporation is located, upon the complaint of the corporation, a majority of the directors or a creditor or claimant, and upon such notice to all of the directors and such other persons interested in as the court considers, essentially may enlist the help of the court to carry out any proceedings related to the winding up of the corporation. We'll talk about what that means in a few minutes. It is essentially a detailed claims process, kind of like bankruptcy. And if you look at it, let's look at the subsections of the statute. Subsection A2, presentation and proof of all claims brought against the corporation that we talked about before during that 60-day period, including fixing a time within which and the manner in which such proof shall be made and the person to whom such presentation shall be made. In other words, putting a little more detail into the procedures we looked at that are usually self-executing if the company does it themselves. The court can also issue the stay of prosecution of any proceedings against the corporation. In other words, this functions like a bankruptcy court stay that freezes all pending and active litigation and bars the initiation of new litigation against the dissolving and winding up company. It gives the court the power to approve settlements of claims, assuming that they're disputed, and they usually are. It gives the court the right to determine the rights of holders of shares. Now we're talking about what is a fair distribution of liquidation proceeds after all these claims have been paid. It goes on to talk about the court's power to oversee the final accounts of the directors or of the liquidators of the company, the ability to fill any vacancies on the board or to appoint liquidators, even to appoint a receiver. And it goes on and basically spells out the powers that a court has in a 1701.89 judicially supervised liquidation process. I'm not sure if any of you have had bankruptcy, but why might someone want to enlist the 1701.09 procedures rather than filing for bankruptcy? Well, there are a number of reasons. First of all, it's probably a lot cheaper to go through this process than it is to go through a federal bankruptcy proceeding. Federal bankruptcy proceedings involve appointment of a U.S. trustee. There are much more rigorous reporting requirements, documentation requirements, hearing requirements. The 1701-89 procedure is much faster. And as you look at the statute, as we talk through it, you have the ability to customize it in ways that you don't have if you file a federal bankruptcy case. There is no state bankruptcy. It's all federal law. So this is essentially a state version of bankruptcy law, special purpose bankruptcy law that's been adopted under this particular chapter. Oh, the next code in our attendance code for today is the letter A. The second code is the letter A. Whereas all the provisions we've covered so far existed in some form already, the following three sections of what I'll call the dissolution and winding up series of statutes are the new ones that were first became effective May 4th, 2012. Let's first look at 1701.881. This is a detailed description of how claims get processed. Remember, when we looked at the more general statute, it talked about the fact that as a dissolving company, we have to send notice by certified mail or registered mail to creditors or potential creditors, giving them 60 days to submit their claim. But it really doesn't provide any other detail in terms of how these claims get processed once they get sent in, presumably within the 60-day period. If claims do come in during the claims period, the statute says that within 90 days after receipt of the claim, and at least 30 days before the expiration of the 5-year period specified in Division A of Section 1701-88, the corporation has to send out a notice basically indicating whether they are accepting or rejecting a claim that's been submitted. It goes on to say that a claim against a corporation is barred if a claimant whose claim is rejected this way does not commence an action to enforce the claim within 30 days after the corporation mails the rejection notice. So, just to review, creditor has 60 days to send in the claim. Company has 90 days to give it thumbs up or thumbs down. If it's thumbs down, creditor has 30 days to file a lawsuit claiming breach of the statutes we've been talking about. Now you'll see that within that same 90-day period that the claim comes in, the corporation has the right to respond to the creditor, offering them security for the claim, especially if it's a claim that is contingent, conditional, or unmatured. So let's say there's a creditor who says, I may have a claim against you. I'm filing it within this 90-day period. Oh, I'm sorry, within the 60-day period. The company can respond to that, well, it is contingent and it is conditional. Here's what we're going to do. We're going to set aside, a percentage of what you think your claim might be, and we'll set that aside for you. If the company communicates that to the creditor, and if the creditor doesn't do anything within 30 days, they're going to be deemed to have accepted that offer that the company made to satisfy the claim. This is in subsection B. All right. Let's look at 1701.882. This has to do with lawsuits that are filed regarding claims during the dissolution process. So this is fairly straightforward. It says a dissolved corporation shall pay claims made and not rejected. That makes sense. Post the security offered and not rejected if someone has agreed to accept that sort of security for a contingent claim that we talked about just now. And it will post security that may be ordered by the court under subsection C of 1701.881. It will also make any payment required by the court if the court is supervising the dissolution and winding up under 1701.89. An interesting subsection of 1701.882 is subsection C, which says, in the absence of fraud, the judgment of the board of directors of the dissolved corporation as to the provision the corporation made for the payment of all claims shall be conclusive. Now, this again is yet again our reference to the business judgment rule and the principle that these boards of directors retain control, even in dissolution, as it relates to how much, whether to honor claims, how much to pay out for claims. I think that's interesting. All right, let's look at 1701.883. This is called liability of a shareholder of a dissolved corporation. As I mentioned before, lots of folks believe that when they file papers of dissolution, they are off the hook and they can go to their retirement not worrying about that mess that they left back in Ohio when they went out of business. This is the statute you've got to tell your client about that they're not going to want to hear about. It says that the dissolution of a corporation shall not affect the limited liability of a shareholder with respect to transactions occurring or acts or omissions done or omitted in the name of or by the corporation. That's good. Dissolution, you can dissolve, but you still enjoy limited liability for things that happened beforehand. That doesn't evaporate for that period of time. So that's the good news your client likes to hear. However, actually I should say subsection B spells out the fact that you are, as a shareholder, assuming there's no fraud involved, the amount you receive in liquidation caps your liability for claims against the corporation if someone is trying to somehow make you liable for the obligations of the corporation. Let's say they're making a piercing the corporate veil argument. In the context of the dissolution and winding up process. Subsection B limits your liability in this scenario to what you received in liquidation from the corporation. Now, that being said, there remains liability under 1701-88B2, which we talked about before. The good news is that there is a partial cap on liability based on the amount of distribution received. The bad news is that there still remains some liability under 1701-88B2. 1701.88B2, of course, is the 5-year statute of limitations for a shareholder to file an action during the dissolution process. Okay, time for another true story. 2 doctors decided to form a corporation for practicing medicine. This is actually a special form of corporation governed by Chapter 1785 of the Code, a professional association, like Kelly and Keller, LPA in our last case. It's limited, you can only have shareholders who are licensed professionals. It also applies to doctors, accountants, lawyers, architects. Anyway, at the time they formed the entity, one of the doctor's accountants filed some papers in Columbus, but there was no corporate record book. And by the way, this happens all the time. A client will tell you, oh, our accountant formed our corporation for us. And you'll find that all he did was file that 1-page articles of incorporation. They haven't done anything else that we've talked about. So that's what happened here. The accountant filed some papers in Columbus. There was no corporate record book. There were no share certificates, no corporate resolutions, no minutes of the incorporator, no code of regulations. Both the doctors were equal shareholders, and they both thought they were directors. And they weren't sure if they were officers because there were no records. As busy as they were, they really didn't get around to any kind of a formal shareholder agreement between the two of them. Things went well for the first few years because they were excited about starting their practice and they were busy, and they pretty much divided everything 50-50. At some point, for some reason, the doctors had a falling out. One doctor was not working as much as the other, and since they had operated in this 50-50 world, it became apparent after a while to the doctor who worked a lot that this wasn't fair. And of course, the accountant who did such a wonderful job setting them up was the same accountant who was making sure each doctor got his 50%. Oh, by the way, the accountant was brought to this party by the doctor who was a bit of a slacker. As you might guess, the slacker had little incentive to see this situation change. What to do in this type of scenario? Well, we have 1701-91. We touched on this provision earlier in the semester when we talked about shareholder or director deadlocks, you'll recall. This is the ultimate tool for resolving a deadlock within a corporation. In those cases where the founders of the company have chosen to share power and control equally, but did not take the trouble to put in place a procedure for resolving deadlock. Oh, by the way, the next code letter is F. F as in Frank. The next code letter is the letter F. All right, so let's take a quick look at 1701.91. The statute talks about the instances in which a corporation can be judicially dissolved and its affairs wound up. Number one, there can be a court order in an action in quo warranto brought by the state. Number two, and that's fairly rare. The second one is by an order of the Court of Common Pleas, pursuant to an action brought by holders of shares entitled to dissolve the corporation voluntarily. Look back at 1701.87. When it's established that any of the following are true: its articles have been canceled or period of existence has expired. That's easy. The corporation is insolvent or unable to afford reasonable security to those who may have dealt with it, and that it is necessary in order to protect creditors that the corporation be judicially dissolved. Letter C, that the objects of the corporation have wholly failed or are entirely abandoned, or that their accomplishment is impracticable. Let's say the business was put in place to build a construction project, and they couldn't raise the money, and the folks who were the founders of this thing are refusing to dissolve it and continuing to draw money out of the coffers to pay for operating expenses. You can file an action for judicial dissolution as a shareholder because the objects of the corporation have wholly failed, for instance. It goes on to say that another instance is when there's an order of the Court of Common Pleas pursuant to an action brought by shareholders entitling them to exercise at least 2/3 of the voting power of the corporation on the proposal when it is established that the shareholders are deadlocked. If you read through the statute, you'll see there are a few other instances when the corporation has been engaged in criminal activities, for instance. It goes on to say that the complaint for judicial dissolution shall be verified, meaning signed by the actual parties and not their lawyers. And it has to set forth a list of who the shareholders are, what their names and addresses are, so that the court can get all of these folks involved in this rather extraordinary procedure. Upon filing of the complaint, the court will set a hearing, and the parties are allowed to appear represented by counsel. And as you know, this may mean directors and officers with their own counsel, shareholders with their own counsel, and out of this evidentiary proceeding, there will be some sort of a decision rendered by the court that may be for judicial dissolution and may also include the provisions of 1701-89 saying, yes, we're ordering this dissolved, and by the way, we, the court, are going to exercise our powers under 1701-89 to control and oversee how this winding up process actually works in terms of detail. So that brings us to Sapienza versus Materials Engineering, one of the cases that I sent to you with the packet last night. So what's going on here? We have a corporation owned by two shareholders, and one of the owners is accused of diverting corporate opportunities to this company called Geotech. And he also was stonewalling efforts to sell the company. The corporation files suit and includes a count for dissolution. And what does the court do? It dismisses the dissolution cause of action, and this appeal follows. How did the court characterize this sort of procedure? Well, they describe it as I alluded to before, an evidentiary hearing regarding the sufficiency of evidence in support of the claimant's allegations of irreparable deadlock. The accused owner argued that the corporation is still viable and therefore it shouldn't be dissolved. The court in this case found sufficient evidence in support of 1701.91A4, which we looked at before. Just to remind you, that section says that the court can order dissolution under 1701.91. It can occur by an order of the Court of Common Pleas in which the corporation has its principal office in an action brought by one half of the directors when it is established that the corporation has an even number of directors who are deadlocked in the management of the corporate affairs and the shareholders are unable to break the deadlock by, for instance, electing new directors, which is what they would do, or when it's established that the corporation has an uneven number of directors and the shareholders are deadlocked in voting power and unable to agree upon or vote for the election of directors as successors to the directors whose terms would normally expire. In other words, 50-50 directors or uneven number of directors, but inability of the shareholders to elect directors because it's time to elect new directors. After the court recounts the fact that in prior meetings of directors, there had been complete disagreement, attempts to schedule shareholders meetings were unsuccessful because of the lack of cooperation between the shareholders. And essentially, in the midst of this is this issue of diversion of corporate opportunities that we've seen before as a violation of a shareholder's fiduciary duties to the other shareholders in a closely held corporation. The court has no problem in coming to the conclusion that there's deadlock in place. And the court says there's no doubt that the parties are in complete deadlock. One party wishes to end the corporation while the other wishes to continue on. Although the day-to-day activities are still happening, the governance of the corporation is at a standstill. And so the court doesn't have much trouble in the end determining that judicial dissolution is mandated by the quote clear language of 1701.91, end quote. Now, there is a dissent in this case. And what's the dissent's argument? Well, that the statute does not require a finding by the court of deadlock. Rather, the standard of review should be abuse of the trial court's discretion. According to the dissent, there was evidence of less than complete deadlock. And he goes on to say that the deadlock only occurred after the one owner sued the other for the alleged diversion of corporate opportunities. That's a pretty decent argument that you should look at this prior to the time of the dispute that caused the lawsuit to try to judicially dissolve the corporation in the first place. Oh, by the way, the last character of the attendance code is the letter U. The last code is the letter U. What I hope that you've gotten out of this lecture today is that you can set up a corporation in about 5 minutes in its simplest form by simply filing the template articles of incorporation that we talked about, have been talking about throughout the semester. Once the corporation is set up, though, and as it starts to do business and incur liabilities both internally and externally, ending the corporation is much, much more difficult, and it's become even much more difficult than even 8 years ago before the latest laws were passed. If you are advising a client, if you're being asked by a client to dissolve a corporation, I hope you think about today's lecture and quote a fee that's substantially higher than the fee you charge to form the corporation in the first place. Again, it's fact specific, but as hopefully you've seen, there's a lot more work involved in taking down one of these corporations than setting it up in the first place. If you haven't looked at the statutes as you've watched this, try to look at them or look at the live hyperlinks when I send out the live PowerPoint tomorrow, because there will be questions on the final regarding dissolution of corporations. All right, so next week we are on to our very last week of class, and even though this class is called corporations, we're spending the week talking about limited liability companies. Why? Because about 99 out of 100 new entities that you will form will be limited liability companies. It is by and large and far and away the most popular form of entity for small businesses these days. And so that's why we spend a whole week on it. You'll see that there's a substantial amount of reading in terms of the statutes. I mentioned before that limited liability companies are a lot like a mashup between a corporation and a partnership. And as you read the statutes and read the cases, you'll get a flavor for that. And that's what we're going to talk about in large part is this partnership heritage and the corporation heritage that make up the fabric of limited liability companies. So please read all the materials before next week's class. As I mentioned, I believe that we are going to do this through a Zoom meeting. And so we'll be doing this in real time. When you send me the attendance code for today, you should also send me your preference for a time on Tuesday and or Thursday that you would like to participate in the Zoom call. I'll send out the invitation. You all will need to be available to log in to that Zoom room meeting and have a camera on your phone or on your computer as well. So I think this would be a good way to wrap up the year. As I said, I'll be able to share my screen with you, so you'll have all the materials in front of you, hopefully just like you would if you were sitting in a class. And I'll try to keep these sessions as short as we can, given the fact that it's the last week of the year. But it is substantial material, so please read up on it. There'll be questions, multiple questions on the final regarding limited liability companies. That is all I have for tonight. I hope everybody stays healthy and stays well, and I will talk to you next week. Bye-bye.